Let me paint a picture for you. You wake up on a Monday morning. You need to pay your mortgage. You open your banking app and your balance is showing normally, but every transaction is blocked. You call the bank, you wait on hold for 40 minutes. When someone finally answers, they tell you your account has been placed under a precautionary hold, and they can't tell you exactly when it will be lifted. Your mortgage is due in 3 days. This is not a hypothetical. This is happening to real people over 65 right now across the country under a set of laws that most of them have never heard of and that give banks extraordinary power to freeze accounts with almost no warning. And here's what makes it worse. Most people in this situation have no idea they have rights. They don't know they can challenge the freeze. They don't know there's a federal agency that forces banks to respond within 15 days. They don't know that if the freeze was unjustified, there are real consequences for the bank, but only if you know how to trigger them. Today I want to talk about what actually happens after a freeze. Because I get a lot of questions about this. Lucien, my account got frozen. What do I do now? And the answer is not just call your bank and hope for the best. There are specific steps in a specific order that get results. And there's one step in particular that most people never take that causes banks to move faster than almost anything else. I'm Marcus Grave, and today we're talking about your rights when a bank freezes your account after 65 and exactly how to exercise them. If you're new here, welcome. This channel is about translating financial rules into plain language so you know your options before you need them. Subscribe before we dive in. Let's go. Before I get into what you can do, I want to spend a few minutes on why this is happening, because understanding the why actually helps you navigate it more effectively. Here's the honest truth. Elder financial exploitation is a massive, documented problem. We're talking about an estimated $28.3 billion lost every year by Americans over 60, according to AARP's recent research. Romance scams, fake grandchild emergencies, sweepstakes fraud, investment schemes, caregiver theft, it's relentless. And for a long time, banks had very little legal cover to intervene, even when they suspected something was wrong. If they froze an account and turned out to be mistaken, they could be sued for denying someone access to their own money. So regulators stepped in. FINRA Rules 2165 and 2166 now allow financial institutions to place temporary holds on disbursements when they have a reasonable belief that financial exploitation is occurring. More than 30 states have passed safe harbor laws giving banks legal immunity when they freeze accounts in good faith. The theory is sound. Stop the exploitation before the money is gone, not after. But here's what those laws also created. A situation where the bank faces almost zero downside for freezing too aggressively, and real liability for failing to freeze something that turns out to be fraud. When you structure the incentives that way, you get exactly what we're seeing in 2026, a surge in freezes, many of them completely legitimate, but a significant number that are excessive, unjustified, or applied to transactions that any reasonable person would recognize as routine. And the people caught in the excessive freeze? They're on their own, unless they know their rights. One more thing I want to flag here, because it almost never comes up in these conversations. There's a legal concept called escheatment. If your account stays frozen or inactive long enough, typically around 5 years, the bank can surrender the account to the state as abandoned property. You don't lose the money permanently, but recovering it from the state takes time, involves paperwork, and you generally only get back the cash value at the time of escheatment, not any interest or growth earned after. This is a real risk for a freeze that drags on unresolved, and it's another reason why knowing how to push back and push back fast matters. Okay, let's say it happened. Your account is frozen. Here's what you need to understand about your rights in this situation. Right 1. You are entitled to know why. When a bank freezes your account, you have the right to know the reason. This seems obvious, but in practice, frontline customer service reps often give vague answers like, "There's a hold for security purposes," without further explanation. That is not sufficient. You can and should specifically ask, "Can you tell me the exact reason this hold was placed, which department authorized it, and what the specific regulatory basis is?" Getting this information in writing is even better. Ask them to send you the explanation by email or mail. Knowing the specific reason matters enormously because it determines which response path makes sense. A freeze triggered by a suspected fraudulent transaction requires a different response than a freeze triggered by outdated documentation, which requires a different response than a freeze tied to a suspicious activity report. Right 2. You have the right to escalate immediately, not just wait. Here's something most people don't do. When a frontline customer service rep tells you the hold can't be lifted right now, that is not the end of the road. You can ask to speak with the compliance department directly, not a supervisor in the call center, the bank's compliance department. These are the people who actually manage regulatory holds, and they have authority that general customer service reps do not. Use these exact words. I'd like to speak with someone in your compliance department about a hold that I believe was placed incorrectly on my account. That phrasing signals that you know what you're talking about and that you're not going to be pacified with generic hold time estimates. Right 3. You can dispute the freeze in writing. A verbal complaint over the phone creates no durable record. A written dispute does. Send a letter or email to the bank's compliance department, not general customer service, stating clearly that you dispute the hold, that you believe it was placed without adequate justification, that you are requesting immediate written explanation of the regulatory basis for the hold, and that you are requesting the hold be lifted within a specific time frame. Keep a copy of everything you send and note the date. The act of putting a dispute in writing changes the bank's obligation. They now have a documented claim they have to address, not just a phone call they can log and close. Right 4. You can file a formal complaint with federal regulators. And this is the step that gets real results. This is the step most people never take, and it's the one that moves banks fastest. Here's why. The Consumer Financial Protection Bureau, the CFPB, accepts complaints specifically about bank account issues, including unjustified holds and freezes. When you file a complaint with the CFPB, here's what happens. The complaint is formally submitted to the bank, and the bank is required to respond, typically within 15 to 60 days. Banks take CFPB complaints very seriously because the CFPB tracks complaint patterns and uses them to inform enforcement actions. Filing a CFPB complaint is free, takes about 10 minutes at consumerfinance.gov, and creates a federal record of your complaint. If you're dealing with a national bank, one chartered by the federal government, you can also file with the Office of the Comptroller of the Currency, the OCC, at helpwithmybank.gov. For credit unions, the relevant regulator is the ncua. I want to be realistic here. Filing a CFPB complaint doesn't guarantee your freeze gets lifted tomorrow, but it does mean the bank is now managing an open federal complaint on top of your freeze, and the compliance incentive to resolve your situation quickly shifts meaningfully. Right 5. In serious cases, you have legal options. If a bank holds your funds for an extended period without adequate justification, and that hold causes you real financial harm, missed mortgage payments, overdrafts, inability to pay medical bills, you may have legal recourse. An attorney who handles consumer banking disputes can advise you on whether your specific situation rises to the level where litigation or a formal legal demand makes sense. Many consumer attorneys offer free initial consultations for exactly these situations. I'm not suggesting everyone with a frozen account needs a lawyer, but for situations where the freeze is clearly unjustified, extended, and causing real financial harm, knowing this option exists matters. Let me give you the exact sequence. This is what an effective response looks like when a freeze hits. Step 1. Get the specific reason in writing within the first 24 hours. Call the bank immediately. Ask specifically, what is the regulatory basis for this hold? Which department authorized it? And what documentation do I need to provide to have it lifted? Write down everything they tell you, including the name of the person you spoke with and the time of the call. If they can send you the explanation in writing, by email or letter, ask them to do that. Step 2. Gather your documentation immediately. Don't wait for the bank to ask. Based on the reason they give you for the freeze, proactively gather everything that shows the transaction or situation was legitimate. If it was flagged because of an unusual transfer amount, gather bank statements showing your history with that recipient. If it was flagged because of outdated ID on file, gather your current government-issued ID and recent proof of address. If it's related to a power of attorney change or a recent death in the family, gather those legal documents. Walking into the bank or sending documentation proactively, before they formally request it, signals that you're organized and speeds the review process. Step 3. Escalate to compliance, not customer service. Call back and ask specifically to speak with the bank's compliance department. Use the language I mentioned earlier. I'd like to speak with someone in your compliance department about a hold I believe was placed incorrectly on my account. If they tell you they can't connect you directly, ask for the compliance department's mailing address and the name of the compliance officer. You need a specific person and address for your written dispute. Step 4. Send a written dispute the same day. Email or mail a formal written dispute to the compliance department. State your name, account number, the date the hold was placed, the reason given to you, and your position that the hold was placed without adequate justification. Request written confirmation of when the hold will be lifted and what documentation, if any, is still required. Keep a copy. Step 5. File a CFPB complaint if the freeze isn't resolved within 48 hours. Go to consumerfinance.gov/complaint. Create an account. It takes about 5 minutes. Select bank account or service as your product type, then problems caused by my funds being low or account freezes, depending on the specific options presented. Describe your situation clearly and factually. What happened, when it happened, what the bank told you, what you've done to try to resolve it, and what outcome you're seeking. Attach any written documentation you have. Submit. The CFPB will forward your complaint to the bank within 1 business day. Banks are required to respond. This is the step that most effectively accelerates resolution without requiring a lawyer. Step 6. File with the OCC or NCUA if the CFPB doesn't produce movement. If you're banking with a nationally chartered bank and the CFPB complaint doesn't produce a response within 2 weeks, file a parallel complaint with the OCC at helpwithmybank.gov. If you're with a credit union, file with the ncua. These regulators have direct oversight authority over those institutions that the CFPB doesn't always exercise in individual complaint cases. Step 7. Consult a consumer banking attorney if the freeze extends past 30 days without resolution. A freeze that lasts more than 30 days with no clear resolution path is beyond what these self-help steps are designed to handle on their own. At that point, a brief consultation with a consumer banking attorney, many offer free initial consultations, helps you understand whether you have a viable legal claim and what the fastest path to resolution looks like with legal pressure applied. Not every freeze situation is the same, and I want to address a few specific scenarios that come up often. The bank says they filed a suspicious activity report and can't tell me anything. Banks are legally prohibited from disclosing that a suspicious activity report, a SAR, has been filed. So if you're told they can't discuss the reason, it may mean a SAR is involved. This doesn't mean they can hold your funds indefinitely. It means the situation has a law enforcement dimension that makes it more complex. In this scenario, consulting an attorney is a more urgent priority than in a standard freeze situation, because the resolution path is different when a SAR is involved. My family member froze my account to protect me, and I didn't authorize it. This is a situation that's more common than people realize, and it's genuinely complicated. Under most state safe harbor laws, a family member claiming concern about elder exploitation can contact a bank and request a protective hold. If this happened to you without your consent and you believe it was done inappropriately, the dispute process is similar, but you'll also need to make very clear to the bank, in writing, that you are a competent adult who is exercising your own financial decisions and that the hold was not requested with your knowledge or consent. In serious situations where family dynamics are involved, an elder law attorney is the right resource. I got a letter saying my account may be turned over to the state as abandoned property. This is the escheatment warning I mentioned earlier. If you receive this letter, act immediately. Contact the bank, confirm your account is active, and update your contact information. The escheatment process exists for accounts the bank genuinely can't locate an owner for. An active, responsive account holder stops that process immediately. Don't set this letter aside. Here's the bottom line. Banks have real legal authority to freeze accounts after 65. And in many cases, they're using it correctly to stop actual fraud. But the same rules that give them that power also create situations where the freeze is excessive, unjustified, or applied to a perfectly routine transaction. And when that happens, most people don't know they have options beyond sitting on hold and hoping for the best. You have rights. You can demand a written explanation. You can escalate to compliance, not just customer service. You can file a CFPB complaint that forces a federal response within 15 days. You can go to the OCC or NCUA if that doesn't move the needle. And in serious cases, you have legal options that banks respond to very differently than they respond to a phone call. The 7 steps I walked through today are not complicated. They're just not something most people know about until they need them, which is usually at the worst possible time. If you know someone over 65 who banks on their own and has never heard of the CFPB complaint process, send them this video. Knowing these steps in advance is infinitely better than learning them during a freeze when your mortgage payment is 3 days away. Subscribe for more breakdowns of the financial rules that affect people in retirement, explained before you need them, not after. I'll see you in the next one.